Welcome back to Artificially Informed, the podcast series that offers an in-depth look at the Florida Attorney General's Government in the Sunshine Manual, 2025 edition. I'm Joel Chandler, and as always, this episode is produced with the extensive use of artificial intelligence. I write the prompts and review and edit all of the output. In today's episode 20, we're covering the final comprehensive sections of Part 2, Public Records. We'll be navigating pages 178 through 206 of your manual. Our discussion will bring us through E. Statutory exemptions, general principles, F. Federal law, and the Florida Public Records Law, G. Fees for inspecting and copying public records, H. Remedies and penalties, and finally, I. Maintenance, storage, and retention requirements. This episode is packed with critical information, so it will be significantly longer than our usual 15 minutes. Let's begin by looking at the overarching rules for public records exemptions. Segment 1, E. Statutory exemptions, pages 178 to 182. Starting on page 178, we delve into E. Statutory exemptions. We've touched on many specific exemptions for different record types throughout our discussion, but this section lays out the general principles that apply to all statutory exemptions from the Public Records Act. First, 1. Creation of exemptions, 1, on page 178. This principle is fundamental. An exemption from Florida's broad public records law can only be created by a specific act of the Florida legislature or by a provision in the Florida Constitution. A public agency cannot decide on its own to make a record confidential, nor can a private contract make a public record confidential. The power to exempt rests solely with the legislative and, in specific cases, the constitutional authority. This reinforces the idea that openness is the rule and confidentiality is always the exception. Next, on page 179, we have 2. Strict construction, 2. This is a vital rule of interpretation. When a court looks at a statutory exemption from the Public Records Act, it must interpret that exemption strictly. This means the exemption should be applied only as narrowly as its language allows, and it should not be expanded by implication or by a broad reading. The goal is to give the broadest possible effect to the public's right of access. If there's any ambiguity, the interpretation should favor public access. This principle aligns perfectly with the overarching policy of transparency. Moving to page 180, we discuss 3. Retroactive application of new exemptions, 3. This principle deals with what happens when the legislature creates a new exemption to the Public Records Act. Generally, new exemptions are not applied retroactively. This means if a record was public when it was created or when a request was made, a newly passed exemption usually won't make it confidential after the fact. The public's right to access is generally determined by the law in effect at the time the record was created or requested. Also on page 180, we find 4. Retroactive application of statutes eliminating confidentiality, 4. This is the flip side. If the legislature passes a new law that eliminates the confidentiality for a type of record that was previously exempt, that new law can be applied retroactively. In other words, records that were once confidential might become public if the legislature removes their exempt status. This reinforces the strong public policy favoring transparency. Next, on page 181, we clarify the 5. Difference between exempt and confidential records, 5. While these terms are sometimes used interchangeably in everyday language, they have distinct legal meanings under Florida law. A confidential records, 5A, on page 181. A confidential record is typically one that is protected from public disclosure, and its unauthorized release can carry civil or criminal penalties. Confidentiality often implies a stronger level of protection, and sometimes the law limits who can even see these records internally within an agency. B. Exempt records, 5.B, on page 182, An exempt record is simply one that is not subject to public inspection requirements under the Public Records Act. While it's not publicly accessible, its unauthorized disclosure might not carry the same penalties as a confidential record, and it might be accessible to certain internal government personnel. The distinction often comes down to the severity of the consequences for unauthorized release. Finally, for this section on page 182, we discuss 6. Discovery of exempt or confidential records, 6. This clarifies that even if a record is confidential or exempt under the Public Records Act, it might still be discoverable in a legal proceeding, like a lawsuit. The rules of civil or criminal procedure govern what information must be shared between parties in litigation, and these rules can sometimes compel the production of records that are otherwise protected from general public access. So an exemption from public records law doesn't automatically mean it's exempt from discovery in a court case. Segment 2, F Federal Law and the Florida Public Records Law, pages 183 to 184. Now moving to page 183, we discuss F Federal Law and the Florida Public Records Law. This section addresses how federal laws can impact Florida's public records. First 1. Application of federal confidentiality requirements to Florida public records. 1. On page 183. If a Florida public agency receives or maintains records that are subject to federal confidentiality requirements, Florida law generally recognizes and upholds those federal requirements. This means if a federal law or regulation explicitly makes certain information confidential, a Florida agency holding that information cannot simply release it under state public records law. This ensures consistency and avoids conflicts with federal statutes like HIPAA, Health Insurance Portability and Accountability Act, for medical records, or FERPA, Family Educational Rights and Privacy Act for student records, which we touched on in episode 11. Next, on page 184, we have 2. Copyrighted records, 2. This section deals with how intellectual property rights, specifically copyrights, interact with public records law. A. Copyrights held by agencies, 2A, on page 184. If a public agency itself holds the copyright to a record, meaning they created it and own the intellectual property rights, that record is still a public record and accessible under Chapter 119. The agency cannot use its copyright to deny public access. However, the requester might still be bound by copyright law regarding the use of the copied material, e.g., they can't necessarily reproduce it for commercial gain without permission. B. Copyrighted material obtained by agencies, 2B, also on page 184. If a public agency obtains copyrighted material from a private entity like proprietary software, a licensed report, or a copyrighted map, that material still generally remains a public record and is accessible. However, the agency cannot facilitate copyright infringement by allowing someone to make unauthorized copies. If doing so would violate federal copyright law. The agency would typically provide access for inspection, but may have limitations on making copies if it would constitute infringement. Segment 3. G. Fees for inspecting and copying public records, pages 185 to 192. Moving to page 185, we tackle G. Fees for inspecting and copying public records. This is a very practical section that deals with what agencies can charge you when you request records. First, 1. Inspection of public records, 1, on page 185. Generally, agencies cannot charge you a fee just to inspect public records. The right to inspect is a fundamental right and is usually free of charge as long as you comply with reasonable conditions. The idea is to make viewing records accessible without a financial barrier. Next, on page 186, we have 2, copies of public records, 2. While inspection is often free, agencies can charge a fee for providing copies of public records. The general rule is that the fee should be limited to the actual cost of duplication. This typically means the per-page cost for paper copies, e.g., 15 cents per page for single-sided copies, or the cost of the digital media, like a CD or USB drive. If electronic records are provided, agencies cannot profit from providing copies. Now, a very important and often debated area. 3. Special service charge for extensive use of clerical or supervisory labor or extensive information technology resources. 3. On page 186. This allows agencies to charge more than the basic copying fee under specific circumstances. If a public records request requires extensive use of agency resources, they can charge a special service charge for the time spent on clerical or supervisory labor or for using information technology resources. Let's break down this special service charge in detail. A meaning of the term extensive, 3A, on page 187. The term extensive is key here and is generally defined by the courts. It doesn't mean just a few minutes or hours of staff time. It implies a request that requires a substantial amount of time or resources beyond what's normally required for routine public records requests. It's usually interpreted as something that significantly interferes with the agency's ability to perform its regular duties. There's no specific hourly threshold, but it's generally understood to be more than a few hours. B. Meaning of the term information technology resources, 3.B, on page 187. This refers to the agency's computers, servers, software, and other technological infrastructure used to locate, process, or produce records. If a request requires a significant amount of IT staff time or specialized technological effort, e.g., running complex queries on large databases, extracting data in a specific format, then a charge for these information technology resources might be permissible. C. Cost to review records for exempt information, 3C, on page 187. Agencies can include the cost of clerical or supervisory labor involved in reviewing records to identify and redact confidential or exempt information as part of the special service charge. This time is considered necessary to fulfill the request while complying with confidentiality laws. D. Calculation of labor cost, 3.D, on page 188. When charging for labor, agencies can only charge for the actual hourly rate of the lowest paid employee who is qualified to perform the work. They cannot charge the hourly rate of a highly paid supervisor or attorney if a lower paid staff member could do the work. This keeps the cost reasonable for the requester. E. Reasonable deposit or advance payment, 3.E, on page 188. If a request is going to incur a substantial special service charge, usually over $100, the agency can require a reasonable deposit or advance payment from the requester before they begin the work of compiling and reviewing the records. This protects the agency from expending significant resources only to have the requester abandon the request. Moving to page 189, we discuss 4 requests for information regarding costs to obtain public records. 4. If you're faced with a potential special service charge, you have the right to ask the agency for an estimate of the cost before they start the work. The agency should provide a good faith estimate to help you decide how to proceed. Next, on page 189 is 5. Requests for free copies of public records, 5. Generally, the law doesn't require agencies to provide free copies of public records, even to individuals who claim indigence or a public interest. However, an agency can choose to waive fees if it serves a public purpose, but they are not legally obligated to do so. Also on page 190, we have 6. Authority to charge for development overhead or travel costs, 6. Agencies generally cannot charge for costs related to the development of records, the cost of creating the original record, general overhead like rent or utilities for the office, or for travel costs incurred by staff to go somewhere to access records if that's part of their normal duty. These costs are considered part of the agency's operating expenses and cannot be passed on to the requester as part of a public records fee. Moving to page 191, we cover more fee-related issues. 7. Fees to obtain agency records held by private companies, 7, on page 191. If an agency's public records are held by a private company, like a cloud storage provider or an archival service, the agency cannot charge the requester any additional fee beyond what would normally be charged if the agency held the records itself. The cost of retrieving those records from the private company is usually considered an agency operational cost, not a charge to the requester. 8. Sales tax, 8 on page 191. Agencies generally cannot charge sales tax on public records copies. 9. Confidential records, 9, on page 191. If a record is entirely confidential or exempt, the agency should not charge any fee for it. There is no public record to provide. 10. Requester makes her own copies, 10, on page 191. If a requester brings their own equipment, like a portable scanner or a camera, to make copies of public records themselves, the agency generally cannot charge a copying fee, only potentially a special service charge for staff supervision if the process is extensive. This provides an alternative for requesters to minimize costs. Finally, for this fee section on page 192, we have 11. Fee issues relating to specific records, 11. This section points out that certain types of records might have specific statutory fee schedules that override the general rules. A. Clerk of Court records, 11A, on page 192. These records, held by the clerk of the circuit court, have very specific fee schedules set by statute. 1. County records, 1101, on page 192. This refers to records where the clerk acts as the county recorder, e.g., deeds, mortgages. 2. Judicial records, 11A2, on page 192. This refers to records related to court cases. Both have statutory fees that differ from Chapter 119's general fees. B. Department of Highway Safety and Motor Vehicles Crash Reports, 11.B, on page 192. As we discussed in episode 15, these reports have specific rules for access and associated fees, often tied to their initial confidentiality period. Segment 4, H. Remedies and Penalties, pages 192 to 203. Now, moving to page 192, we reach H. Remedies and Penalties. This critical section outlines what happens when the Public Records Act is violated and how enforcement actions are pursued. First, 1. Voluntary Mediation Program, 1, on page 192. Florida law provides for a voluntary mediation program for certain public records disputes. This is an option where a neutral third party can help the requester and the agency try to resolve a dispute without going to court. It's a way to resolve issues faster and less expensively. Next, on page 193, we discuss 2. Civil Action 2. This is the primary way the Public Records Act is enforced in court. If an agency violates the law, a person can file a civil lawsuit. A Remedies 2A, on page 193. These are the types of actions a court can take to remedy a violation. 1. Mandamus Petition and Alternative Writ 2A1, on page 193. This is a common legal tool used to compel an agency to perform a specific duty, like producing public records. A mandamus petition asks the court to order the agency to release the records. An alternative writ is a preliminary order telling the agency to either produce the records or show good cause why they shouldn't. A. Hearing 2A1A, on page 194. If a mandamus petition is filed, the court will hold a hearing to determine if the agency has unlawfully withheld records. B. In-camera inspection 2A1B, on page 196. In some cases, if an agency claims a record is exempt or confidential, the court may conduct an in-camera, meaning in chambers or privately, inspection of the record. The judge reviews the record themselves, away from the public and the parties, to determine if the claimed exemption actually applies. This is done to avoid releasing genuinely confidential information publicly while still allowing judicial oversight. 2. Injunction 2A2, on page 197. A court can issue an injunction, which is a court order prohibiting an agency from continuing to violate the Public Records Act or compelling them to take certain actions to ensure compliance. 3. Declaratory relief sought by agencies, 2.A3, on page 197. Sometimes an agency itself might be unsure about whether a record is public or exempt. In such cases, the agency can ask a court for declaratory relief, which is a judgment from the court clarifying the legal status of the records. This allows the agency to get a definitive ruling before acting. 4. Damages, 2A4, on page 197. While rare, courts can sometimes award damages, monetary compensation, in public records cases, especially if there was willful violation or demonstrable harm. However, the primary focus is usually on compelling access, not on awarding damages. B. Procedural issues, 2.B, on page 198. This covers various legal procedures in civil actions. 1. Discovery, 2.B1, on page 198. In a public records lawsuit, parties can use standard legal discovery tools, like depositions or interrogatories, to gather information relevant to the case, such as details about the agency's handling of the request. 2. Mootness, 2.B2, on page 198. A case becomes moot if the issue is no longer a live controversy. For example, if an agency finally releases the records after a lawsuit is filed, the court might deem the request for access moot because the records have been provided. However, a case might not be moot if there are still questions about attorneys' fees or ongoing violations. 3. Service of process, 2.B.3, on page 199. This refers to the formal legal notice that must be given to an agency when a lawsuit is filed against them. 4. Stay, 2.B.4, on page 199. A stay is a court order temporarily stopping legal proceedings. In public records cases, a court might issue a stay for various reasons, though it's generally discouraged if it delays public access. 5. Venue, 2.B.5, on page 199. This refers to the proper geographical location, county, where a lawsuit should be filed. Public records lawsuits are typically filed in the county where the agency is located or where the records are maintained. C. Attorney's fees and costs, 2.C, on page 199. This is a very powerful incentive for compliance. Section 119.12 Florida statutes mandates that if a person successfully sues an agency to enforce the Public Records Act, the court shall assess a reasonable attorney's fee and cost against the agency. This provision is meant to ensure that individuals are not financially deterred from enforcing the public's right to access. It ensures that the watchdogs of government transparency can afford to challenge violations. Finally, on page 203, we have 3. Criminal and non-criminal infraction penalties, 3. Beyond civil lawsuits, there are direct penalties for individuals who violate the Public Records Act. Section 119.10 Florida statutes states that any public officer or employee who willfully and knowingly violates the Public Records Act is guilty of a misdemeanor of the first degree. This means an intentional violation can lead to criminal charges, including potential jail time and significant fines. Less severe violations might be handled as non-criminal infractions. This underscores the seriousness of adhering to public records laws. Segment 5, I. Maintenance, storage, and retention requirements, pages 203 to 206. Finally, on page 203, we conclude Part 2 of the manual with I. Maintenance, storage, and retention requirements. This section deals with how public records are kept and managed. First, 1. Maintenance and storage of records. 1. On page 203. Agencies have a legal duty to maintain and organize their public records in a way that allows for efficient inspection and copying. This means they must have proper record-keeping systems, whether paper or electronic, and ensure records are not haphazardly stored. The law requires orderly management to facilitate public access. And next, on page 204, we have 2. Delivery of records to successor, 2. When a public officer leaves office, they have a legal duty to deliver all public records that were made or received in their official capacity to their successor in office or to the designated records custodian. They cannot take public records with them when they leave. This ensures continuity of government operations and preservation of public information. Also, on page 204, we discuss 3. Transition records of certain officers-elect, 3. This applies to newly elected officials before they officially take office. It clarifies that any records they create or receive during the transition period, after being elected but before being sworn in, that relate to official business are also public records. This prevents a dark period where preparatory work for a new administration might be hidden from public view. Moving to page 204, we cover 4, retention and disposal of records. 4. This is governed largely by Chapter 257, Florida statutes, and rules from the Department of State, which outline how long different types of public records must be kept and how they can be disposed of. Retention schedules, 4A, on page 204. The Department of State establishes official retention schedules that dictate the minimum amount of time various types of public records must be kept. Agencies must follow these schedules. They cannot simply destroy records before their scheduled retention period is up. This ensures records are preserved for historical, legal, and administrative purposes. B, disposal of records, 4.B on page 205. Once a record has met its required retention period, it can be lawfully disposed of, e.g., destroyed. However, this must be done in accordance with approved disposal methods outlined in the retention schedules. Unauthorized disposal or destruction of public records before their time is illegal. C. Exempt records, 4.C on page 205. Even if a record is confidential or exempt from public access, it must still be retained according to the applicable retention schedule. The exemption only applies to its disclosure, not its retention. Agencies cannot destroy exempt records just because they are confidential. D. Evidence obtained by law enforcement agencies, 4.D, on page 206. Specific rules apply to the retention and disposal of evidence obtained by law enforcement. These often have longer retention periods and special handling requirements due to their role in criminal investigations and legal proceedings. Finally, on page 206, we have E, duplicate records, 4.E. This clarifies how duplicate copies of records should be handled. Generally, if an agency has multiple copies of the same public record, once the original or master copy has met its retention requirements, the duplicate copies can often be disposed of sooner, but this is guided by specific retention schedules to avoid unnecessary storage. This concludes our incredibly detailed exploration of Part 2, Public Records, bringing us to the very end of the main body of the Florida Attorney General's Government in the Sunshine Manual. Thanks for listening. Until next time, remember, the truth dies in the dark, so let's leave the light on.